part of this second panel on the histories of the UNWCC. So this panel brings together a presentation about the foundation, the history, and also the legacy of the United Nations War Crimes Commission. The first two presentations will report on the questions of investigation of war crimes and punishment of their perpetrators. The first on the importance of the Commission on the responsibility of the authors of the war and on enforcement of penalties, and the second on the collaboration between the Polish government in exile and the UNWCC. Then the two remaining presentations will show advanced reflections on the UNWCC when presenting the UNWCC as a model for a more extensive approach to war crimes prosecution today, and the fourth on crimes against and affecting cultural heritage. So our first speaker, Ewan Lawson. So Ewan Lawson will speak about digging the foundations for the UNWCC, Britain, Paris, 1919, and atrocity propaganda. So Ewan Lawson is a PhD candidate at the Center for International Studies and Diplomacy at the School of Oriental and African Studies. So interestingly, he has been also a former British military officer with experience in military planning, information operation, and also military cyber operation. So he has served for 27 years before joining the Royal United Service Institute in London as a senior research fellow in the military science team. He researched, wrote, and spoke even on peacekeeping, warfare, information warfare, and also their military use of cyberspace and cyber in national security strategy. And so he has a master's degree from King's College London and the Open University, and his PhD is about the development of international regimes to deal with sexual violence and conflict. So we have here a real expert, and looking forward to listen to you on the foundations for the United Nations War Crimes Commission. So Ewan Lawson, the floor is yours.
Ann-Sophie, thank you very much. So it makes me sound much better than I really am. So I'm going to try and share some slides, just 1 second. Unfortunately, one of the downsides of military experience is that you end up kind of a slave to PowerPoint. So let me just get those running. Here we go, good. As Ann-Sophie mentioned, my PhD thesis is looking at how international legal regimes have developed around crimes of sexual violence and conflict, but very much with the UNWCC at the hub of it, with the UNWCC being a primary focus. And the way I'm looking at it is through a theoretical framework of societal constructivism, but with the methodology really more of a traditional historical approach, looking at social and diplomatic history and using that to fill a sort of constructivist theoretical framework. I'm going to focus on the UK's role in the thesis in establishing the regime, but I also want the broader outcomes and how they impact on prosecuting sexual violence in conflict. And this in part was driven by this narrative which exists, which is, nothing happens to do with sexual violence and conflict before the ICTY. And of course, there's clearly bags of case studies now, that is clearly not the case. And part of my interest was the way in which the UNWCC's work on sexual violence and conflict does not come out of the blue. It builds very much on the list, the general list of crimes that were identified at the peace process, but which is specifically included rape and enforced prostitution. And I'm afraid I've fallen down something of a research rabbit hole, which I suspect happens to a number of people during PhD theses, and looking at the role of atrocity propaganda, and particularly how that influences the UK's approach approach to the Paris peace process. And really, the focus of this is about this idea of the so-called rape of Belgium. Now, Germany attacks France through Belgium in August 1914, the infamous Schlieffen Plan. And from the very outset, there are atrocities committed against the civilian population, including sexual violence. And some of this has its roots in a fear going back to the Franco-Prussian War in the late 19th century of partisans, effectively, franc tireurs, of the civilians attacking soldiers. And the German military is brought up with this fear, and there's certainly no justification for it, but this seems to have contributed to some of these atrocities. But what I think makes this interesting for our work is that there is a conflation of these atrocities with the attack on neutral Belgium. The language that's used is very gendered. Belgium is a female victim of violence, and this becomes quite significant in how we think about this. And I would argue that this is then carried through in the way that people approach the identification of war crimes at the Paris peace processes. Britain is significant in this because Britain is a guarantor of Belgian neutrality. It is one of the key signatories of the London Treaty, as to be fair indeed is Prussia against Germany. And this breach of Belgian neutrality causes outrage in political life. It's very much a focus of the early days of the war, and this is very much reflected in the press. And the fact that the German Chancellor is supposedly said that the London Treaty is nothing more than a scrap of paper. This apparent disregard for international law plays very hard into the initial framing of the First World War in Britain. However, these atrocity narratives are clearly becoming part of the conversation. But as early as September 1914, so within a month of the war breaking out, there is a apparent desire on the part of the British government to establish what the real facts are, to avoid any sense that that these are stories, that they are being made up. And the Prime Minister, Asquith, calls for an investigation. And he establishes, the Home Secretary then establishes a committee to conduct this investigation under Lord Bryce. And Bryce is selected for a couple of reasons. The first is that he's a bit of a Germanophile. He has spent a lot of time in Germany. He was quite anti the Anglo-French Entente. So therefore, he is not seen as being particularly pro the war. He had called for neutrality in early 1914, for Britain to be neutral in early 1914. However, looking ahead to, as we start in a moment to talk about propaganda, it's also not insignificant that Bryce had spent a lot of time in the United States and was considered credible as a commentator by the Americans. And there's little doubt that this was one of the things that was seen as important, meaning that any report he produced would be credible in the eyes of the Americans, who even at this early stage, the British were very keen to engage in the war on their side. The report that's produced by this committee, the Bryce Report, or as it's sometimes known, the Blue Book, is essentially a catalogue of war crimes, as they would later be framed, of atrocities primarily against civilians, but also against soldiers. But in the report, it was emphasised that this was evidentially collected. This was not just, forgive me, it's not just people just collecting stories, that the people who went out to collect the stories, to collect the evidence, were lawyers or legally qualified or legally trained. Now, I'm not suggesting for 1 minute that this evidence would have met court standards, the evidence that's collected in the report. And unfortunately, that evidence has subsequently been destroyed at the end of the war. So we can't now look at it and make a judgment on it. But it was collected from a range of sources. A lot of refugees had arrived in Britain, both civilian and military. So the evidence is collected from Belgian civilians, from Belgian and British soldiers, but also from German soldiers' diaries, where German soldiers had either been killed or captured in those early days of fighting. And this collection of evidence confirmed widespread atrocities, including a significant number of crimes of sexual violence. And the report was published widely. It was published in a number of languages, including in German, and indeed, whilst I won't talk any more about it just now, there were equivalent reports produced by both France and Belgium, and indeed a sort of counter report produced by the German government. What I want to move on to now is that the role that this evidence was then to play in British propaganda, because I think that then impacts in the way that in the future people look at Paris peace process and the war crimes elements of the Paris peace process in quite a negative light. And I picked these two posters just as indicative of the sort of images. And what you have here is Belgium portrayed as a violated woman, and the posters are interesting because one is British and is very much they're both recruiting posters effectively, but the other one is to destroy this mad brute. Arguably the worst image is actually from America. So this is much later in the war. So this narrative of Belgium, Belgium as a female character being raped, is being used right the way through the war as a symbol of why the Allies need to continue the fight against Germany. And as we'll see, this becomes potentially problematic. The propaganda that's produced, as I've already indicated, is used domestically and internationally. And there is a link between the Blue Book, the reporting, and the imagery, in the sense that the stories were taken from the Blue Book, the evidence was taken from the Blue Book. It was then spread through the media, through pamphlets, through the newspapers, internationally, as well as within Britain. Now, part of the problem with this is that because it was used in propaganda, it becomes the subject of significant post-war critiques. So, the British one of which is, most famous British one of which is by Arthur Ponsonby, which is published in the mid to late 1920s, which is called Falsehood in Wartime. And Ponsonby basically seeks to suggest that the propaganda describes things that haven't happened, that they are made up, and they are simply about encouraging violence and encouraging the war to continue. But I would argue, if you look at the work that is going on in the British government as we get towards the end of the war about war crimes and prosecutions, those are very much about the treatment of prisoners of war. They're to a certain extent about aerial bombardment of civilians. They're much more. They're not so much now about the predation against civilians. Because effectively from 1915, when the Western Front becomes stable, the British are not seeing much evidence of this predation against civilians. But what that campaign has done is maintained in the public mind, and therefore how the public then mind influences political decision making. The focus on sexual violence as a potential war crime. So the so what's of this particular story. So I think the first thing is that the Paris peace process and the report, this is the longest title in the world, of the Commission on the Responsibility of the Authors of War and Enforcement of Penalties, which I generally refer to as the Commission, is significant in the UNWCC's identification of potential war crimes. Indeed, it's the very list that is published in that report that is initially introduced in London in 1943-44 as the list of war crimes. And that includes rape, which has not been mentioned as a war crime prior to this point, or an international war crime prior to this point, and enforced prostitution. But one of the challenges in considering the Commission's work is it's often disregarded, partly because of its failures to deliver. You know, there are only a few trials in Leipzig, which are generally seen as failing, and they're not for things including crimes of sexual violence, but they're also undermined by the role of atrocity propaganda. And I would argue that I think societal constructivism is a valuable approach for considering the freedoms and constraints that exist in diplomatic processes, including the UNWCC. And at that point, I'll stop.
So thank you so much, Ewan Wilson, for your great presentation. So now we will give the talk to Dr. Dominika. I'm sorry if I mispronounce this. Unwcc. Is it okay? Okay, so she is going to talk about collaboration between the Polish government in exile and the United Nations War Crimes Commission, Polish War Crimes Office, and the first charges. So Dr. Dominika Unwcc is a lecturer at the Willy Brandt Center for German and European Studies at the University of Wrocław in Poland. She was a law student at the Faculty of Law, Administration, and Economics at the same university, and she has also studied ancient culture, philosophy, and German studies. So she has a broad understanding of the history of European civilization and also of European law. So Dr. Dominika Unwcc, the floor is yours, and we are really looking forward to hear your presentation on one of the central exile committee in London in framing the UNWCC.
Thank you very much for the introduction. First of all, for the invitation to this conference and our panel. Let me share my screen so that I can show you the presentation I prepared and also findings from the archives I discovered during my research. Can you see the PowerPoint presentation or the whole screen of mine, because I don't see it?
Hi, at the moment, all we can see is a black screen. Your presentation isn't showing.
Okay, then once again. Is it working now?
No, unfortunately, we can still just see, it's just saying that you're sharing your screen. We can't actually see the presentation.
Okay, then maybe.
It's just come up now.
Now it's okay,
Sure.
And you see my presentation. Great. So once again, thank you very much for the invitation. I will start my talk with a general remark or consideration on the studies on studying the archives of United Nations War Crimes Commission that follows my personal experience, but after this morning's panel, I think it is a common experience of scholars researching these archives. I have this impression that on the studies, during the studies on the legacy of the United Nations War Crimes Commission, we are constantly discovering new facts. We are going back and back in time in the chronology of the history of prosecution of war crimes. and marking new significant dates in this chronology. This involves, for instance, the creation of UNWCC, the declaration of St. James's Palace, works of already mentioned legal associations as London International Assembly. This also involves the restoration of memory of individuals who were actively involved in the preparations for the prosecution of war criminals and whose role in defining the principles of international criminal justice has been forgotten or marginalized. The case of Eastern European scholars, officials who initiated the international debate on punishing war crimes and contributed to the works of UN War Crimes Commission is only one among many examples, but I will address this specific issue in my speech. I will focus on the case of the Polish government in exile. The postulate to punish individuals responsible for breaches of laws and customs of war was placed among the main political goals of the Polish government in exile already in autumn 1939. This resulted in the development of a complex war crimes policy, which included the documentation of war crimes, information campaigns on Nazi atrocities, attempts together with other allied countries to develop principles of common war crimes policy, and also the legislative works on the legal framework for the future trials of war criminals. In the resolution of 15 November 1939, the Polish cabinet has officially protested against the persecution of civilian population under Nazi rule and announced retribution for these crimes. 2 weeks later, special resolution against the extermination and atrocities of occupiers was adopted. This exposed the necessity of bringing the perpetrators to criminal liability, the need to gain international support for this demand, and to inform the international public about the scale and gravity of Nazi crimes. To support this objective, Polish diplomats coordinated multiple information campaigns supported by white books, conferences, exhibitions, and other media activity. The key issue was the documentation of atrocities. First instructions for the leaders of the Polish underground movement concerning the gathering of evidence of crimes committed by the occupying forces was sent to the country in November 1939. This gave rise to the extensive documentation of war crimes collected by the Polish authorities. The central body coordinating these works was so-called German Register at the Polish Ministry of Internal Affairs that was created in autumn 1941. In November 1943, it was transformed into the Polish War Crimes Office, chaired by attorney from Kraków, Jerzy Litawski. The German register contained at that time approximately 4,000 names of alleged war criminals, which explains why Polish War Crimes Office has filed that high numbers of charges to the UNWCC from the beginning of its operations. Until July 1945, Polish War Crimes Office filed 41 charges listing over 1,000 accused individuals. Shortly after the establishment of Litawski's office, its structures extended. In spring 1944, special Jewish section managed by Manfred Lachs was established. Its aim was the evaluation of collected evidence of the persecution and extermination of Jews, preparation of related UNWCC charges, and collaboration with Jewish organization in London in that respect. In August 1944, a branch of Polish War Crimes Office was created in Scotland and started interrogations of Polish prisoners of war and soldiers forcibly drafted into the Wehrmacht, who in summer 1944 had been emancipated from the German captors. Many of them were former prisoners at Mauthausen, Gusen, or Dachau and provided testimonies and lists of perpetrators and victims to the Polish authorities. A special interrogation questionnaire was prepared by Jerzy Litawski for this occasion, and this form was subsequently used by the UNWCC for the recommendations for the interrogation of enemy prisoners of war of January 1945. In recognition of Jerzy Litawski's commitment, he was appointed as legal officer at the UNWCC in Secretariat in May 1945 and became secretary to the first committee. He held this position after the end of Commission's operational work in 1948. Also, Stefan Glaser, who was the Polish delegate to the UNWCC until September 1944, was involved in Commission structures. He was the chairman of the third committee on legal questions. Stefan Glaser was professor of criminal law and procedure at the University of Vilnius and recognized international legal scholar. During the war, he was the delegate to Cambridge Commission on Penal Reconstruction and Development and held different posts at the government in exile, but special attention should be paid to his role, to the role he played in the Legislative Commission at the Ministry of Justice. In spring 1942, Stefan Glaser, together with other eminent scholar, Professor Wacław Komarnicki, has introduced in the Legislative Commission draft of the decree of the President of Polish Republic on the criminal liability for war crimes. The decree was ratified on 30 March 1943, and it was the first act of internal law issued by one of the Allied countries, defining the legal grounds for prosecution of war criminals. It was designed as a lex specialis to the Polish Penal Code of 1932. It defined the individual liability of persons belonging to German Reich, its allies, and to other countries cooperating with them for violations of international law and crimes against Polish state, Polish legal bodies, and Polish citizens committed after 31st August 1939. It applied the principle of exterritorial jurisdiction following the provisions of the Polish Penal Code. It established criminal liability for crimes endangering life or physical health for concentration camps, sexual violence, expulsion, forced labor, forced drafting into enemy army, also destruction of cultural goods and private public property of great national value. During the works on this legal act, Stefan Glaser emphasized the significance of effective jurisdiction over war criminals and underlined that it required legal foundation. He also emphasized the importance of distinguishing new forms of criminal acts committed by the German Reich from offenses defined in the criminal codes. According to Wacław Komarnicki, these new types of criminality resulted from the concept of total war and were characterized by large-scale violence against the civilians, persecution and extermination of national, ethnic and religious groups, and their cultural heritage. The systemic and organized character of Nazi crimes that were committed within the legal structures legitimizing committing these atrocities was another important distinction. Therefore, the question of individual liability for crimes committed within the binding positive law was of great importance. The presidential decree established criminal liability of perpetrators, giving and carrying out the orders to commit a crime, persons helping them to escape responsibility, as well as liability of judges passing sentences under laws violating international law. Additionally, the decree imposed life penalty or capital punishment for judicial murder. In May 1944, Stefan Glasser has presented to the UNWCC proposal concerning the principles for determination of liability for war crimes that was developed from the rules defined in the decree of March 1933 and from the rule of the liability of persons giving and carrying out orders to commit a crime. The criminal character of Nazi law, the problem of crimes committed in the majesty of German law order was addressed in multiple charges filed by Poland. They concerned judicial murders, introduction of special criminal law for Poles and Jews, denial of fair trial by special penal codes, so-called Sondergerichte and Standgerichte, who were sentencing in occupied territories, but also mass executions of civilians without a fair trial. These measures were considered by the Polish lawyers as instruments of policy of humiliation and systematic extermination, which should constitute a separate war crime, as suggested by Stefan Glasser during the UNWCC meeting in May 1944. The second crime that Poland wanted to be included in the UNWCC war crimes list, basing on the already mentioned list of the Commission of Responsibilities of 1919, was the crime of taking hostages. It concerned the groundless arrests of civilians by the occupying authorities, defined by Glasser as indiscriminate mass arrests for the purpose of terrorizing the population. This crime was also listed in many Polish charges concerning the mass executions and imprisonments of civilians committed during and after the German invasion in 1939. In this context, the problem of prosecution of social and cultural groups was strongly emphasized. Among first Polish charges, we can also find many charges concerning the concentration camps, including the extermination of European Jews at Majdanek, Bełżec, or Chełm, but also cases concerning, for instance, medical experiments at the Ravensbrück concentration camp. Great attention was also paid in the Polish indictments to the destruction of cultural heritage and persecution of the Polish intelligentsia. The extermination of educated classes was and devastation of culture and scientific goods were considered as one of the methods of total war that aimed at disintegration of culture and transformation, here I quote, transformation of Polish nation into a community of slaves deprived of their own culture and national tradition and forming a reservoir of labor for the benefit of the German race. I use this quote to conclude my speech and also to contextualize the arguments presented in my talk in the context of the development of definitions of new international crimes, especially crimes of humanity and the definition of the crime of genocide. Thank you very much for your attention, and I will be very happy to answer any questions or comments. Thank you very much.
Thank you so much, Dominika, for your presentation. We will now turn to the next presentation. The next presentation is War Crimes Against Humanity Continue, and it is presented by Nafisa Kiani, who is a very active postgraduate student in global public policy at SOAS. So she worked for the House of Commons, UK Parliament since 2014. She has been a business support manager for education and engagement. And right now, so as I said, she's a postgraduate student at SOAS in public policy, and also have undertaken an BSc in politics and then BSc in speech therapy. And she is also very active in presenting and sharing panels online. And one, for example, was discussing the role of women from the Global South in developing international relations and human rights. So Nafisa Kiani, the floor is yours. Looking forward to hearing your presentation on War Crimes Against Humanity Continue.
Thank you. So I'm just going to share my presentation. Just bear with me, please. Okay. So I just want to check that you can see my presentation.
Yeah, we can.
Great, thank you. So I'm going to start by giving background information on the United Nations War Crimes Commission. The United Nations War Crimes Commission supported countries in prosecuting war criminals, being involved in legitimation and reviewing cases. The United Nations War Crimes Commission's records and work offer lessons informing current action and policy making. United Nations War Crimes Commission's work involved law reports, legal debates, trial transcripts and summaries in current attempts to hold perpetrators accountable for atrocities via legal means. A small number of cases involving sexual violence undertaken during World War II were taken seriously by the United Nations War Crimes Commission. This is because the United Nations War Crimes Commission member states successfully investigated and prosecuted these crimes, holding direct and indirect perpetrators accountable for their crimes. The United Nations War Crimes Commission offered witness protection and sensitivity to witnesses participating in these crimes. The work of the Commission demonstrates quick and fair trials. It offers a way for international information gathering and approval granting mechanism, like the United Nations War Crimes Commission, to give governments in exile multilateral legal assistance in building cases whilst armed conflict is raging. The United Nations War Crimes Commission succeeded in stopping Nazis from escaping from Allied custody, forming liaisons and connections to Supreme Headquarters Allied Expeditionary Force after the war. To attain justice, the United Nations War Crimes Commission executed military tribunals, resolving situations involving intricate crimes. The United Nations War Crimes Commission, Nuremberg and Tokyo tribunals succeeded, uniting various countries, ideologies, and regional groups against Nazism and Japanese fascism. The United Nations War Crimes Commission failed to prosecute Allied personnel for their crimes, linking to the question connected to victors' justice. A criticism of the Commission is its remit had limitations, supporting prosecutions of enemy personnel for offences committed against the United Nations during World War II. As ways forward, the second version of the United Nations War Crimes Commission can examine the scale and scope of prosecutions and indictments of war criminals by the first United Nations War Crimes Commission, considering it as a model for a more extensive approach to war crimes prosecutions today. Although the Germans who launched war crimes against the Jews were held accountable through court trials and arrests, ongoing tensions exist worldwide where Uyghur and Indian Muslims face sexual violence and torture because they are Muslim. Although the War Crimes Commission held perpetrators of violence accountable, Muslims face injustice worldwide which needs tackling. The War Crimes Commission must continue its work, holding individuals into account. Strong evidence needs submitting to the international criminal courts for injustice against Uyghur Muslims. In Palestine, Iraq, Syria, Libya, India, and other places, large-scale massacres occur involving genocide and crimes against humanity. The Afghan people are suffering, many of whom are hungry, homeless, living in poverty at the hands of foreign occupation forces, US drones, losing families, homes, and livelihoods under the Taliban. This is an illegal war undertaken for the previous 20 years by the US and NATO forces upon the people of Afghanistan. Countries must unite to overcome atrocities against Muslims with no concern that supporting the truth will sever ties with other countries. The international community must stand by the Afghan people, offering humanitarian assistance, welcoming refugees and asylum seekers. It is difficult to distinguish how the Syrian conflict might be resolved, or where a United Nations War Crimes Commission-like mechanism might allow large-scale prosecutions for war crimes and crimes against humanity. Syrian civilians experience violations, abduction, kidnapping in South Syria. Improvised explosive devices are increasing. 85% of boys and men are victims of explosives. Health services are in shortage during the pandemic, which is immoral. Torture and sexual violence are partly why Syrians fled their country, being obstacles for dignified refugees and displaced people returning to Syria. Syrian women face acts of violence. There's deteriorated food and water due to the weak economic condition in Syria. Syrian activists like Khalid Helmi have had to flee Syria, being internally displaced, living separately from family members, and have a brother, a postgraduate student, detained in Syria for no valid reason, who has been missing. And activists like Khalid need support in finding their missing family member, who has been missing for over 10 years. The United Nations, one can argue, didn't attain its objective of maintaining peace and security in Syria until today. In northeast Syria, US-led coalition and Syrian Democratic Forces caused deaths of civilians in areas controlled by extremist group Islamic State. Syrian-Russian military alliance killed 20 civilians in an unlawful strike. Those forces ruined and made unusable 50 healthcare facilities. So one can argue, how can the Syrian conflict be resolved? The Syrian regime must end brutal behavior, upholding EU sanctions. All parties should follow human rights law, combating terrorism. Food, health, and educational needs of Syrians need improvements. The United Nations should offer political guidance, actions, and recommendations, as political, not military solutions can assist. The UN can refer to global actors to combat the UN can refer to global actors to combat the pandemic in Syria. Russia and Turkey should follow the 5th of March additional protocol ending hostilities, causing permanent ceasefire nationwide. Parties should follow the UN-facilitated political process resolution 2254 to end conflict, offering lasting peace to Syrians. How can we overcome the persecution of Uyghur Muslims? In terms of recommendations, to overcome the detention, physical, mental, and sexual torture and persecution of Uyghur Muslims, support can be shown to the Uyghur Tribunal, national jurisdictions, and the International Criminal Court case, by not only individuals but Muslim and Western countries worldwide. Last year, a complaint was filed to the International Criminal Court as China commits unlawful acts against international law, including rape of millions of Uyghur Muslims, forced sterilization, the selling of Muslim organs to other countries worldwide. Further evidence of jurisdiction is needed to strengthen the case, to allow prosecutors to investigate so individual perpetrators can be arrested and prosecuted for crimes against humanity. Saleh Hudaya, the Prime Minister of the East Turkestan government in exile, believes that Muslim communities and organizations can place pressure to Muslim countries to urge China to resolve the situation on the persecution of Uyghur Muslims. However, Muslim countries' ties with China being a superpower prevent them from doing so out of fear that this might impact their relationship with China on the longer run. However, as Muslims, it is their duty to condemn crimes against Muslims. The United Nations Security Council should commit to a convention on genocide. Saleh Hudaya has asked the United States and Canada to grant refuge to those Uyghur Muslims who fled the genocide. He has advocated for the cause and has spread awareness on the matter. In addition, Rodney Dixon, a Temple Garden Chambers lawyer, has filed a complaint against China at the International Criminal Courts for committing genocide against the Uyghurs and other Turkic people. All countries worldwide must come together to resolve the ethnic cleansing and genocide of Uyghur Muslims by supporting the International Criminal Court's case. This is a process that will take time. Religion remains an issue as there are primitive acts because of religion, which are not acceptable. There should be no impunity for crimes against humanity. How can we resolve the situation in Palestine? One can suggest that a two-state solution creating an independent state on Palestine can lead to durable peace. The United Nations need to place pressure on Israel to establish security. An independent Palestinian state is needed, with refugees being allowed to return to their homes. Without any action, accountability and consequences, Israel will continue to trample international law. The United Nations resolutions and the Fourth Geneva Convention protecting civilians in times of conflict must be implemented. This is how all forms of apartheid and colonialism can be defeated. The Palestinians have the right to Resolution 3236. The right to self-determination, national independence and sovereignty, and the right to return to their homes and property. As the Secretary General stated, a free and comprehensive peace can exist amongst Palestinians and Israelis residing side by side as two states. One can agree with the United Nations chief that no amount of humanitarian or economic support will resolve the situation in Gaza or the wider conflict. A lack of progress will only increase radicalization in Palestine. Although projects implemented by the United Nations and donors cause some relief, more work needs to be done. Palestine's future cannot be resolved through international law and negotiations amongst the parties. The situation in Iraq involves unfolding chaos fundamentally linked to the historic religious and ethnic enmity amongst its three major ethnic and religious components, which involve the Shia, Sunnis, and the Kurds. The vicious cycle of violence appears to have no end in sight. It is primarily accredited to the Shia-led central government's marginalizing and alienating policies, coupled with economic deprivation, which have pushed the disenfranchised Sunni Arabs to welcome and support the most brutal Salafist jihadist terrorist organization known as the Islamic State. In reality, the country is unofficially partitioned along ethnic and sectarian lines. Hence, Baghdad and the global leaders must come to terms with this reality. Iraq faces significant challenges in its recovery from the war against the Islamic State. More than 2 million people remain internally displaced, and nearly 9 million people remain in need of humanitarian assistance following the nearly 4-year-long war. In terms of resolving the situation in Iraq, a two-state solution, an independent Kurdish state and a federal Shia-Sunni state can essentially address Iraq's underlying issues. An independent Kurdistan will serve as a model for democracy and coexistence in the broader Muslim world. It will also enable Kurds to more freely engage with the international community and positively contribute to global stability and security. Moreover, a federal Shia-Sunni Arab state with a weak central authority can address the historic sectarian conflicts between Shia and Sunni Arabs. The right to self-determination will reduce the threats of domination and marginalization from one another. It will also limit foreign intervention and help contain terrorist organizations. And this is just my bibliography for the research that I undertook, and I'm happy to answer any questions after the other presenters have finished presenting. Thank you.
So thanks you so much, Nafisa Kiani. So we'll now turn to our last panelist. So our last panelist will speak about, will do a presentation entitled Crimes Against and Affecting Cultural Heritage in the Aftermath of the Second World War. So our panelist is Alice Lopé-Fabrice. She's a PhD candidate at the École Normale Supérieure in Paris and at the Institut des Sciences Sociales du Politique. So she's writing a PhD on cultural heritage, its codification in international law, and also on the question of the responsibility and reparations in international law. So she has published in French, in English, and also in Portuguese on this question on, for example, on the protection of cultural property in the case of South America, or also in the event of a non-international armed conflict, for example. So yeah, Alice, we are looking forward to listen to your presentation. Is Alice here? I don't.
She's not here, and I think she needs to be added into the room.
Perfect. I'll see if I can do that.
Okay, so
Thank you.
can you try to fix a problem or?
Yeah.
Great. Yeah.
No problem.
During that time, maybe we could ask different questions. So, who among the audience would have any question, if you have any? Or maybe Dominica, or yeah, Dominica, please. Yeah.
Yes, I'd have a question to Iwan. Well, thank you to both presenters for the papers. I wanted to ask about the if you have researched on this topic, on the relevance of the Rice reports and this documentation of war crimes of Second World War collected by Belgian government and other allied governments. What was their reference for Belgium in the Second World War, for the Belgian government in exile when attempting to gain international recognition for crimes committed by Nazi Germany? Were there any links or direct connections, direct usage of this materials, of concepts?
Great question, and the simple answer is I haven't. However, what I have found is so a particular British military legal officer, J.H. Morgan, who is involved in collecting evidence in France and Belgium, France particularly in sort of 1914, 1915, and who is then involved in the UK, sorry, wrong, it's not the UK then, in Britain's efforts in Paris in 1919. In 1939, he writes to Churchill and says, you need to remember, we've done all this work before, you know, it already exists and we need to use it again. So I have not yet been able to see, I'm still trying to find anything in the UNWCC archives to see whether that, you know, that can be, you know, can be clearly linked forward. So the UNWCC takes forward that, you know, yeah, well, we have got all this stuff from before. Because of course the time period between, you know, 20 years, 1919 to 1939 is relatively short. So that, you know, there are people who are clearly involved in both campaigns. So nothing specific on the Belgians, but absolutely specific on the British.
If I'm not wrong, I think in these protocols concerning the conference at St. James's Palace, or some conferences that before, this issue is raised by Belgian officials. For sure, in this Polish debate, it is important point of reference. On the one hand, in this international campaign, that Poland, since fall 1939, is suffering as, or even more than Belgium was 20 years before. And of course, there is this narrative of a failure of Leipzig trials, etc., so that we have to act right now to avoid these problems that followed the Versailles Treaty. It is for sure used as important figure in this Polish discourse. Right now, I can say where exactly I found also some mentions on the Belgian side, but probably there are more traces. Thank you.
I'm sure there are, and I think. I think, you know, it goes back to some of the conversations about the dynamics of the different nations who are represented in UNWCC and how they bring, you know, whether it's, you know, Britain and France and their colonial heritage and how they're, you know, protecting that, whether it's, you know, the Western allies, where, by which I mean, you know, the France, Belgium, Netherlands, Britain and the government in exile, versus actually Poland, Czechoslovakia, you know, who have had much more, particularly Poland, much more brutal experiences, but have not got that connection back to Versailles. Indeed, you know, one of the critiques of Versailles more broadly is the creation of some of the states of Eastern Europe, and the fact that those are not. It's tensions on the borders of those that has contributed to the outbreak of the Second World War. I mean, that's a massive simplification, and so much of this is about other factors, including German aggression, fundamentally. So the whole legacy of the Paris peace process, Versailles being, you know, one of those outcomes, is absolutely tainted, and it becomes, I think, quite difficult for some people to be able to take that forward into the conversation.
I think in general.
Oh,
do we
sorry.
have our presenter?
No, unfortunately, she hasn't shown up today, so we won't be having a presentation by Alice. Sorry about that.
So coming back to your point on this comparison, I think there are, well, many links, and this importance of failure of the Leipzig trials and the central figure of Versailles Treaty is important and appearing in so many different contexts during these debates on developing principles of criminal responsibility for international crimes during Second World War. And yes, I think that this regional studies or case studies focused more on simple examples or single examples altogether can bring some new findings and brighter picture of this, yes, significance and connections. I'm always very sensitive when it comes to this appearance of post-First World War trials in this debate during the World War II. Yes, and I'm very excited about your findings and your project.
No, thank you. I think it's a really interesting issue, because for me, Paris peace process is such a massive leap forward from the Hague processes. You know, particularly in terms of sexual violence. You know, in Hague you have, I think they're called, the phrasing is something like crimes against family honour. You know, it's very Victorian. There's no discussion of what we're really talking about. It's alluded to. Yet by the time we get to 1918, 1919, and arguably before that, you know, we're having a much more open and frank conversation about what these crimes really are and how that they should be punished. Bearing in mind that in a number, well, I would argue probably in most militaries' internal disciplinary codes, you know, there was space for the prosecution of crimes of sexual violence committed. So if you look at the Americans and the Lieber Code, which is 1861, I think, you know, that makes rape by an American soldier a capital offence, you know, in the mid-19th century. Yet by the time we get to Hague 30 years later, when we're trying to think about it as an international crime, it's not really being talked about. It's kind of being, you know, it's being alluded to. But the positive for me about the Paris process is that we get it back on the agenda again, and in an open way. The fact that the system then fails is down to so many other things as well. The focus on prosecuting the Kaiser, and the reluctance of many of the states really to be involved in the prosecution of head of state. I mean, you know, the Americans effectively put a coda into the report of the Commission on the Authors and Responsibilities, you know, on exactly that. They think it's wrong to be prosecuting a head of state for a crime of aggression. The Japanese put in something on racism, effectively, as a coda into that report. And I think those, we need to see those developments more positively in a way that they potentially then feed into World War II, rather than there was a very sort of dismissive, negative attitude around the Paris peace processes and the language of Versailles, that it leads to a resurgent Germany. It causes all the border disputes in Eastern and Central Europe that are excuses, but actually in there are things which are absolutely taken forward into the UNWCC and into subsequent processes as well.
So I would have a question to each of you. So maybe the first question would be to Dominika about, so in your presentation, you have spoken about Stefan Glaser and then also Jerzy Litowski. And I wanted to ask you, so in the aftermath of World War II, are these Polish representatives going back to Poland, and are they participating in the prosecution of war crimes, or do they stay into exile? And the next question would be also about Ewa Lawson. So when you are speaking, you're focusing on the British. So do you see any concurrence between the British and the American, which we can witness during World War II, for example, at the London International Assembly? So a kind of competition in codification or in trying to catalog war crimes. And my last question would be to Nafisa Kiani, which has really highlighted the importance of the UNWCC as the model. I wanted to ask you, Nafisa, so what do you think? So we have heard a presentation here on exile of a Polish government in exile. And in your presentation, you touched upon a subject like Syria and Afghanistan. So how do you think that, that the lawyers who are in exile are also playing a role in trying to push international organizations to prosecute or to investigate war crimes? So, for example, I'm working on a case with South Vietnam, and I am seeing how people who went into exile have pushed to try to investigate war crimes, and also has tried to intervene at the United Nations to kind of investigate an act, torture acts or human rights violation. So how do you see that in your study? So thank you all of you for your great presentation. So maybe Dominika, we can start with with the question.
Thank you. Yes, that's the topic I haven't included in my presentation because it's too complex, this relationship between the communist government, this Warsaw government that was recognized in July 1945 by the Western Allies, and the government in exile or with the legacy of the government in exile, because it is a really complex question. One remark just to contextualize is that that were two polarized political fractions, and in general, or the majority of politicians who were associated with the government in exile remained in exile. There were ideological reasons for that, so that recognition of the communist government is the betrayal of Poland, that the Yalta Conference provided unjust world order without including Polish demands after all the suffering Poland has suffered during the Second World War and was actively involved in the armed conflict. The communist government, on the other side, declares all political opponents, including the government in exile, as illegal. After coming back, these people are feared of facing criminal prosecutions, which it's on the margin, had the same legal basis as the trials of Nazi criminals. These first decrees established by the communist government concerning war crimes trials were also criminalizing the activities of political opponents. but that's just the footnote. Coming back to Stefan Glaser and Jerzy Litawski, that are only two among at least 8 to 10 really important figures and representatives of Polish legal scholarships who were involved in this development of Polish war crimes policy during the Second World War. I mentioned only these two names due to the time discipline. When it comes to the United Nations War Crimes Commissions, there are Mieczysław Scherer and Tadeusz Cyprian, who were also listed on the slide related to the UNWCC. They were Polish representatives at the Commission, and Tadeusz Cyprian, who was representing government in exile, came back to Poland, was Polish delegate to the Nuremberg trial, and after that also prosecutor during the trials before the Supreme National Tribunal. The same case was, or the same situation was in the case of Manfred Lachs, who was managing this Jewish section of Polish War Crimes Office. He also came back to Poland and was involved in preparation of Polish indictment for these Polish documents for the Nuremberg trials. And Mieczysław Scherer would be the third person who came back from London to Poland. And what is unknown and has not been researched until now, this direct connection between these two centers of power and between these two between Warsaw and London are crucial for, I think, the success of Polish war crimes trials after 1945, because that were this person who knew about the documents that were collected by the government in exile and filed to UNWCC. Their knowledge, their experience was of great relevance also for the war crimes policy of the communist governments. But the rest, or the majority of lawyers who were active in this circles during Second World War in London, they remained in exile. And their fate and biographies, that is topic for another lecture.
Yeah, thanks so much, Dominika, for your fascinating answers. So Ivan Lawson, please. Yeah.
I'm probably not going to answer the question you asked, Ann-Sophie, but I think you have, if I can go back again, forgive me, to Versailles and to Paris, there are serious tensions in that process between the British and the Americans. Some of that is at a fairly simple level about personalities. You know, the extent to which this process at the highest level is conducted by the three key leaders, by Wilson, by Clemenceau, and by Lloyd George, you know, is for me, I still find quite surprising. You know, that whereas I think now you would expect to see officials running around and having the conversations, it was always the other way around. The principals would have the conversations, and then the officials would have to go off and do what they'd been told to do by the principals. And there is a real tension here, and some of that is because of, you know, Wilson's approach to colonialism, and that is something that we certainly see mirrored again into the UNWCC process, and I think you also see, you know, a tension, particularly in the UNWCC, again at that sort of very senior level, because in many ways the crimes of the Second World War are, particularly against civilians, are just so much more terrible than those of the First World War. That you know, late on in the war, you've still got Churchill talking about, you know, shooting out of hand Nazi leaders, military leaders, no trial, just taken out and shot. And you know, and you've got Stalin, of all people, saying, no, we're not going to do that. We want to have our sort of trials instead, like you show trials. And in that middle of that, you have the Americans, you know, saying, well, you know, actually we need to do something, and let's try and find a kind of middle ground. And some of that, I think, comes out of that legacy of the Paris peace process. And that's the sort of stuff I'm trying to find in the archive now is, I've drawn a causal link that I can't really demonstrate yet between, I can demonstrate in a micro way, I guess, with bits of stuff between Paris and the UNWCC, and I'm just looking now to try and make that much more substantive.
Okay, thank you so much for your answer. So Nafisa, so how would you see the relation between the Polish exile and your case studies you mentioned in your presentation? We cannot hear you. No, we cannot hear you. We still cannot hear you. I think it was linked to your, yeah. You should put back your head. Yeah, I think so. Yeah, we can hear you now. Yeah.
Okay. So yeah, your question was asking me about lawyers in exile and how they have investigated about war crimes, and that links into this article about the contribution of exiled lawyers to the concept of crimes against humanity during the Second World War. And I wanted to add that exiled lawyers have changed the perception of international law into a protector, because they put more weight on the experience of violence and victims' voices than on the early approach of protecting states from violence, like the Belgium motion on the Versailles Conference. And crimes against civilians have always been perceived as the most heinous of crimes. So during the 1940s in London, exiled lawyers within the United Nations War Crimes Commission were amongst the main protagonists to coin the concept of crimes against humanity. And underlying this concept is the assumption that citizens are under protection of international law, even when they are victimized by their own compatriots. So without the engagement of exiled lawyers, mainly from marginalized states, smaller European states, as well as China, they would never have emerged the self-consciously global project of penalizing war crimes on a planetary scale. And even British lawyers in October this year have called upon the Metropolitan Police Service to investigate key government figures in Saudi Arabia and the UAE for alleged involvement in war crimes in Yemen. So I would assert that the notion of exile itself created a global movement and triggered the advent of universalist approaches to law. So exiled lawyers' engagement with and facilitation of legal flows fast demonstrates the significant intellectual role played by marginalized academic juridical actors in a difficult political context in the forging of new globalized legal concepts. Your question was asking me to link Poland with something else. If you can, repeat the question.
No, it was just to see if the Polish experience of exile lawyers also mirror the investigation of Syrian or Afghanistan lawyers.
Okay.
If there is some similarities.
Oh, okay. I haven't noticed any, to be honest, and I feel as though it's a field in which further research can be undertaken. But I wanted to say I noticed a difference in terms of the fact that, with the persecution of the Uyghur Muslims and the genocide, there are British lawyers who are trying to gather evidence to present to the international criminal courts, and they need strong evidence to be submitted to hold the perpetrators into account. That's what I noticed. And also I find there's involvement from political activists to try and overcome the situation in Syria, where they just come forward and speak about their personal experiences. And they tend to say they haven't gained you know, that much support in trying to find a lost family member and trying to reunite with them. And yeah, so I feel as though that's an area that can be improved upon. Yeah.
Thanks so much, Nafisa, for
It's okay.
answer. And I think that we are coming here to an end. If none of you has any further remark. So thanks so much. Thanks so much first, Ewan Lawson, for your presentation, Dominika Uskliwiecki for your participation on Polish exile government, and Nafisa also for highlighting the importance of the United Nations War Crimes Commission as a further model and how it can also play a major role in the future. So it has been really a huge pleasure to chair this panel. I'm very sorry for all the small problems, disturbances during this during this panel. And yeah, it's really a pleasure to have hearing your presentation and also the interactions between your presentation and listening to your answers. Thanks so much.